The Supreme Court ruled this week that law enforcement cannot use a new technique to tap into giant databases to determine if cell phone data can actually be used during an investigation. So, 9 News legal expert Whitney Traylor is joining us here this morning to discuss what this means exactly. So, Whitney, this centers around something known as a geofence warrant. I'm going to assume that most of our viewers don't know what the heck that is.
Yes.
Can you explain what a geofence warrant is and how did it become the center of this Supreme Court case?
Yeah, this is a really interesting case, and this is really dealing with privacy. And as technology advances, there's always issues of how much privacy are we actually entitled to. So a geofence warrant is different than a traditional warrant. So traditional warrant has probable cause, and it identifies a specific area with particularity, saying, hey, we think that there's evidence of a crime in this person's basement, and here's why.
Okay.
Right? With a geofence warrant, they're saying, look, we don't know exactly who may have done what, but we know there was a crime committed in this area. So we want to kind of create this virtual boundary of, let's say, 150 meters, and we want to identify all the cell phone users that were in that area between, this time and this time. And so they go to a tech company, usually it's Google, and Google can then identify and track and say, here's all the cell phone users who were in that area at that time. And so the issue is that a violation of our privacy because you haven't authorized Google to provide that information to the government?
So when ruling on this, it sounds like the Supreme Court basically tied this whole geofence warrant business into the Fourth Amendment.
Yes.
Can you explain that connection?
Right. So that was really the heart of the case. That's a great question in terms of, does this constitute a search under the Fourth Amendment? Because as we know, the Fourth Amendment says you're protected from unreasonable search and seizure. And so the question is, all right, was this a search? If so, then constitutional protections apply. And here the court said that, yes, this did constitute a search, and therefore certain constitutional protections apply, including, do you have a reasonable expectation of privacy in that regard where you're just happen to be in a certain area using your cell phone? And Justice Kagan, she pointed out in her opinion how somebody could be accessing an abortion clinic or going to an hourly motel or going to a certain political campaign. And so certain information could be revealed in that regard. And so how much protection do we want as citizens in that privacy regard?
You would think that a Supreme Court ruling means the case is closed, but we also know that that's not always the case. So right. In this situation, is this a done deal now? Does this close this case?
No, this doesn't close the case. And a lot of times with the Supreme Court, they'll issue a ruling and they'll affirm or reverse, but sometimes they'll remand it back to the trial court with certain instructions. That's what happened here. So they said, nope, this was a search under the Fourth Amendment. So now you have to go back, trial court, and look at the facts and say, was there probable cause that there was evidence of a crime here? Was the warrant with enough particularity? So now the trial court has to look at this under a lens of the Fourth Amendment and say, was this reasonable or an unreasonable search?
Let's bring this back to police, our own local law enforcement. What does this ruling mean for them going forward?
Well, it's going to mean, I think it's going to be a limitation. So this really is a protection of the citizenry as it relates to privacy. So law enforcement is now going to have to be, I think these warrants are going to have to be more specific. They're going to have more information. I think a judge is going to be scrutinizing the request for these kind of warrants in a more specific way, because in this regard, right now, the way they used it in this case, there were hundreds of people in that area. And so do we want our information just completely accessible by the law enforcement just because we were in a certain location? So now I think it's just going to be a more stringent standard. And I agree with it. I think that makes total sense. Just because you're in a location, you shouldn't have your information disseminated.
Whitney, good to have you back on the show this morning. Missed you last week.
Yeah.
In fact, you hit it with so much knowledge just now.
Yeah.
We need to take a break and regroup.
Okay, get it together. Take a breath. So